Once one party files for divorce in New York, what is generally the process or the timeline if the divorce is contested?
Once a request for judicial intervention is filed with the court generally schedules a preliminary conference with either the judge or the court attorney referee. And you will usually get that date probably within a few days to a week or so after you file what the attorneys call the RJI. That's just the acronym. And the actual court date will be usually about 4 to 8 weeks into the future, depending on what the current backlog of the court is. And then you will meet with the judge and or court attorney referee. They will generally go over the preliminary conference order. So that's just an order one can easily find on the court's website. That's newyorkcourts.gov. So it may behoove people to check out the form of that so that they know what issues are being discussed in case their attorney does not discuss that order with them. But generally speaking, the order will go over things like a discovery schedule, what issues are being contested, things of that nature. And then, so you do the preliminary conference, the referee and or judge may have settlement suggestions to make to the parties if they're kind of a little bit apart, but not a tremendous amount apart on the issues. But if things cannot be resolved, then the next court date will be what's called a compliance conference. That will be where essentially the parties will discuss with the court where they are at in terms of exchange of documents, information. That's what's called disclosure. Usually those deadlines for disclosure are set up in the preliminary conference, but sometimes for a wide variety of reasons, everything is not done by the compliance conference. Sometimes people exchange documents, but they don't exchange everything. And so some items are still missing from the original production. And so the court attorney referee can guide the process in completing disclosure. And then usually if deposition dates are not already fixed, they are fixed at the compliance conference. So those will take place as well as the completion of paper disclosure between the time of the compliance conference and the pretrial conference. The pretrial conference, sometimes referred to as the trial ready conference, that is your final conference before the court attorney referee. Sometimes the judge conducts those conferences because that is essentially your final conference before the court sets the matter down for trial on whatever issues still cannot be resolved. So the court will expect that all disclosure issues are resolved by the time of the pretrial conference. If they are not, they will want a very good reason why the disclosure is not completed. They will also want references to attempts to resolve those issues going in. So, the good judges and court attorney referees will not accept from the attorneys that they really didn't do much of anything to resolve disclosure issues and then complain about missing disclosure at the pretrial conference itself. Those discussions should be had amongst counsel in an earnest attempt to resolve those issues going into that final conference. So then if for whatever reason issues cannot be fully resolved at that pretrial conference, then the court will set the matter down for trial. They will discuss with the attorneys how many days of trial they expect. That's often dependent on what issues are being contested. But oftentimes they block out a day or most of a day for each party's direct case, and usually a day or two for any rebuttal or supporting witnesses. and then sometimes even a fifth day for summations, if the court wants oral as opposed to written summations. So typical trials may take place over the course of about 3 to 5 trial dates, though if there's both custody and financial issues, you could almost assuredly be looking at more than 3 to 5 trial dates. That's the 3 to 5 trial dates is usually if one or the other of those core issues are being contested. But if nothing is being resolved, then you're probably looking at 6, 7, 8 trial dates, possibly more, depending on whether they're half day or full day trials. But that's basically the course of a typical contested divorce case.